have with us today Mr. Rajan Jayakar sir, who is known to have dedicated years to preserving and documenting India's rich legal heritage, tracing the journey of our courts from colonial times to the present day. Sir, your work reminds us that the rule of law in India is not just a legal story but a civilizational one. We welcome you wholeheartedly to this conversation with Jyot and LawBeat, which is related to the views of Swamiji. What is your opinion? What is your perception about his opinions on the civilizational value and the constitutional ethos that we hold today?
Yeah. See, the concept of Vasudev Kutumbakam is a concept which is now I think this government is trying to canvass all over the world. And it is catching up that you cannot be, you may be a democracy, but you cannot be segmented into various parts. It has to be the world has to look at itself as a wholesome humanity, because there are so many factors which are destroying the humanity through wars, epidemics, etc. So therefore, this concept is very good. Unfortunately, this concept was not translated into constitution at the time of making of the constitution, because they were, although it was the country was divided on religious lines, and it is true that so many Muslims who were asking for two-nation theory, ultimately when it happened, continued to remain in India. Fair enough. So they were given as same equal rights as the citizens. But while making a team for making constitution, there were no religious heads who could give their opinion, because the people who were there were learned people, people who were in politics, people who were freedom fighters. They were included. Now it's like asking a soldier to draft a constitution. That is not his job. So similarly, people who had taken part in the freedom struggle, maybe they were good at doing that. But to ask them to put up a constitution, of course, I have no complaint about the constitution and its vastness, because it's the longest constitution in the world has ever seen. But the deliberations, etc., go to show that while defining secularism, it did not take the basic principles, not the basic structure, but the basic principles of civilization, which was there much prior to other religions came into picture. It is not as if the world was not running properly and therefore other religions had to come and intervene and say that we are the best. So those principles, only the earlier world was ruling, those principles were not, as a principle, were not included in the constitution, but they were sought to be little steamrolled on the basis of the concept of framers as a secular nation.
Right, right.
So I wholeheartedly say that this particular concept, although it's late in the day, 75 years have gone by, but it's never too late. And if that concept can be understood properly in the light of present definition of secularism, they can still be implemented, because there is nothing. It has got no religious overtone.
Right.
It is how the human life as a Vasudev Kutumbakam, the entire world is looked upon as a family. So there is no religion involved in this.
Correct.
So,
Absolutely,
yeah.
sir.
So therefore, this concept is
The fact that you just pointed out a very important aspect, that you can't ask a soldier to draft something.
Yeah.
I mean, if the matters are related to civilization, if the matter is related to constitutional aspects and the related aspects that we are discussing here today, it is imperative to have voices of constitutional thinkers, public opinion. All of that forms a part of it. Only then we can have possibly the best output to be adhered for the society.
Yeah, the thing is that when the constitution was being drafted, it was presumed that all the people who will be part of the government will be honest. They all will be, as if like the freedom fighters who became constitutional experts, they will all be like this, dedicated to the nation. They could not envisage the kind of government that will follow, where there will be corruption rooted at it, etc. There was a discussion in the Constituent Assembly that we must have legislators who must have a qualification, like a graduation or something. And there were freedom fighters who said that, look, there are quite a few people who may not be technically educated, but they know the pulse of the masses because they have worked in them. So those people will straight away go out of this orbit of being the legislature. So therefore, there is no educational qualification which is mentioned in this. Now the Supreme Court, through judgments, etc., is trying to cure that thing by not introducing a legitimate educational qualification, but by saying that if you are, at least there is a charge sheet filed against you, then you will be disqualified, etc. And government is working on it. The best part is that the opposition is opposing it, because the government says that once a charge sheet is filed against you, then you are debarred for life, because you have shown that you are not this. And the opposition is opposing it because they know that most of the people from their side also will get disqualified.
Correct. Very well
Yeah.
said, sir. On that note, sir, I would come to the judiciary's role in such things. How far do you think that the judiciary has succeeded in balancing the traditional aspects or the civilizational aspects alongside the provisions of the constitution and the dynamic needs of the society? If we look at the present needs of the society, how has it able to, maintain a balance between the civilizational aspects, the present needs, and the constitutional fabric as such?
Yeah, I would divide this into two parts because when the emergency was formed, there was a particular type of viewpoint right from the beginning till the emergency was formed because there was basically only one single party which was really ruling it. So therefore, they always thought that judiciary is something which is part of their own domain and they can do this. Unfortunately, when after the party went out of power, there were two judgments of the Supreme Court which said about judges appointing judges. Now that concept is not there anywhere in the world. But this was when the judgments were given. At that time, again, the ruling party was such that the senior judges were bypassed by Indira Gandhi's government. Judges who gave judgments against the government were not made Chief Justice of India. Justice Khanna is an example.
Right.
Yeah. So that is one part. But now, I'm completely opposed to the idea of National Judicial Commission Act should be abolished. No, it should not be abolished. You can put checks and balances to show that the legislature or the executive does not have a upper hand as compared to judiciary. But you cannot say that the judiciary itself will manage all the judicial affairs. That is not correct because now there are so many things which are coming up. People are saying that if your uncle, father, mother's grandfather is a judge, then you have got a better chance of becoming a judge. So this is what is now coming up. I'm not saying that all children of the judiciary are not good. Like for example, Chandrachud. Now his father was a Chief Justice for almost 8 years. But when Dhananjay became, you cannot apply the same rule because he came on competence. It was not that his father's gene that carried him, but it is his own competence. So there are exceptions, but there are so many other judges also who become just. There is an example of a judge not being a lawyer, because previously there was a qualification of IAS becoming judges.
Okay.
So that IAS person ultimately crept into Supreme Court. He was not a law graduate, nothing. He was an IAS. So he was a diplomat. Yeah.
Right.
So these are the things which should be ironed out.
Right. So basically, accountability more than practice of doing things within the hemisphere of the judicial.
Other thing is, about 20 years ago, I had written to the President of India saying that, look, there are senior lawyers who are quite competent. They don't want to become judges because the salary offered is too poor. It's not that what they earn in a day, they have to slog it out there for a month. At the same time, it is their duty. Like at the time of Vietnam War, every US citizen had to become a soldier for 3 years, 18 to 21. Thereafter, if you want to continue, it's fair enough. Otherwise, you can go back to your profession. Why not these lawyers who want to become seniors advocates? Why not they be pushed into this? You become judge for 3 years. Instead of just criticizing that the quality of justice is gone, people don't understand. You become a judge. If you want to continue, fair enough. Otherwise, go back. So that kind of the quality of judges should improve. Then only the litigation, etc. will come down.
Absolutely, sir. I totally agree with that opinion of yours. With that, sir, we move to the rapid fire section that we have, where we would want to have your instinctive thoughts on certain things. First question being, if you had to fix just one thing in India's justice system today, what would it be? Speed, sensitivity, or structural simplicity?
Speed. Because that is the most important disease which is there in the judiciary. That people have to wait for 20, 30 years. Absolutely. And other thing which is now coming up as a concept is that suppose I am convicted of an offence, but a higher court ultimately says that no, you have committed no offence. Who is to compensate me for my jail term, for my completely this ruining of the life, my family, etc. when I am ultimately held that I am not responsible?
Next question, sir. What, in your view, defines a good state? Strong laws, strong institutions, or strong citizens?
Well, strong institution and citizen will take them. You may have a strong law, but you must have the implementing agency to do it.
Very well said.
Yeah. So therefore, if your implementing agency is not there, what is the point of having a strong law and nobody is doing? I'll give an example of the various these banners, etc. in the city of Bombay. Yeah. There are so many judgments which are passed that they should not be. Whoever is the person who has not obtained permission or whose face is there, that should be caught, etc. But that doesn't happen. You will see just opposite to the High Court a banner coming up.
Right.
when some VIP is visiting Bombay, there are so many people who say, welcome so and so, so and so. But nothing is happening. So laws are only there, the judges also, judgments are, and they are not taking any serious note of this.
Right, right.
Otherwise, if a common man violates a judgment, the judge's order, then he will be taken for contempt and all that. Here, nothing is happening.
Correct, correct. With that, sir, we move to our last question, which is, if the Supreme Court had to look at the basic structure doctrine today again, will it stick to it or will it prefer rewriting it?
I'm not very happy with the basic structure doctrine as is sought to be interpreted today, and particularly Article 140, use of Article 142, because these two things go together. If it has to be reviewed, there must be a strong case for a bench of 15 judges. I don't see any strong case which is there, and I don't see that. The thing is that if it has to be reviewed, first it will go before a 30-judge bench to find out whether at a review is required. If they say review is required, then it will be referred to the Chief Justice, who constitute a bench of 15 judges. I don't see any such cause existing just now which will justify a review, because otherwise it cannot be reviewed by any other means. We cannot pass a legislation to bypass this basic structure. So only review is by higher number of judges, which is not happening now.
All right, sir. With that, we close our interview for today, and we are truly grateful to have you with LawBeat and Jyoth for this conversation. Thank you so much.
Thank you.